justice. As I've been mentioning early on, it's really a matter of character. It's the strength of character and the clarity of vision that an aspirant has to make him or her an ideal candidate for the position. In the first place, sir, judicial experience is not among the qualifications provided in the Constitution. In the first place, administrative skills and administrative experience also are not prescribed as a qualification. Otherwise, the best candidate would be the court administrator. Now, in particular reference to my experience, sir, I take this that if and when I'm appointed to the post, taking on the administrative responsibilities is just it's just the same as what my experience had been when I joined the CHR, when I joined the DOJ. Administering the affairs of an institution does not really require a special or some special administrative skills. It's more of your determination to know exactly what the institution needs in the operational aspect, and having the determination also to put in place the needed reforms. I have had some substantial experience in running institutions. CHR had 13 administrative regions all over the country. We have lawyers. DOJ especially. DOJ is not just the main office, it's not just the National Prosecution Service. I also supervise and have control and supervision over 10 constituent and attached agencies. Now, in the National Prosecution Service, we have prosecution offices nationwide, and we have thousands of personnel nationwide. And in terms of administering the DOJ and its attached and constituent agencies, remember, sir, that these agencies under my control and supervision span the whole gamut of the country's criminal justice system, from investigative to prosecutorial to rendering of opinions, legal to prosecution, and even correction, the correctional aspect of the criminal justice system. I do believe, sir, maybe Supreme Court would be a bit different in terms of the gravity of the responsibilities or the gravity of the needs and challenges of this institution. But given, again, my background, I think I would be up to the task. Although I'm used to really assuming posts, hitting the ground, and immediately thrown into situations where I have to learn so much. My learning curve has always been quite short whenever I assume new posts. Thank you.
Well, if you are as convincing then as you are convincing now, I think you are well qualified. Thank you.
Maraming salamat po.
Attorney Mejia. Attorney Mosngi, Secretary Mosngi, please.
Maraming salamat. Mr. Chairman, magandang hapon ho, Secretary Leila.
Good afternoon.
Before anything else, gusto ko lang sabihin na isang malaking karangalan para sa akin na gampanan ang inyong tungkulan bihing kalihim ng kagarawan ng katarungan sa pagkakataong ito po. Madam Secretary, kayo po ay tanyag, kayo po ay sikat sa ating bansa. Marami po ang inyong tagahanga at marami po kayong supporter. Maraming naniniwala sa inyong mga adhikain. at sa mga tinutulak niyong reforma bilang kalihim ng ating Justice Department. Maaari ko ba yung tanong, ano ho ba ang sa tingin ninyo ang inyong di anyayang trait or katangian? What is your worst character trait, Madam Secretary, you think?
Mahirap po yung tanong na yan. I would rather that other people would really provide that answer, but I can try. Ang isa pong nakikita sa based on experience po, minsan po masyado pong malambot ang puso ko. Actually, in public or when in discharging public duties, I project a very strong image and no nonsense personality. Pero ho, sa totoo lang, malambot ang puso ko. And there are times that I find myself in a quandary, in a dilemma on how to really address specific situations because of that. At ang pangalawa po, malambot nga po ang puso ko, pero grabe naman po ang temper ko. My staff can attest to that. But I'd rather that you don't ask them about my temper. But I'm blessed with a very understanding staff. Alam naman nila yun na hindi naman ako namemersonal kapag po nagwawala ako paminsan-minsan dahil hindi ho masunod yung gusto ko o hindi masunod yung hindi magawa yung nang tama ang pinagagawa ko. I think yun po. Kasi yung although I understand or I know that my bad temper is also in my blood. Thank you.
Salamat po. Marami pong...
Wala na ba?
Meron pa. Marami pong naging kritisismo sa inyong alleged na panlabag dun sa temporary restraining order nung panahon ng gustong lumipad sa ibang bansa ang dating Pangulo, Gloria Macapagal-Arroyo. Sa pagkakataong ito, gusto ko pong itanong sa inyo, kung natanggap niyo po ba ang kopya ng temporary restraining order bago nakarating si dating Pangulong Gloria Macapagal-Arroyo sa airport, susundin niyo po ba ang kautusan ng Supreme Court?
Depende ho. Titingnan ko na muna ho yung language, the tenor, and the terms of the order. As it turned out, conditional po yung TRO. So kung natanggap ko po yun at napansin ko, yun ay kung napansin ko na subject pala to conditions and I had no way of validating at that point kung nasunod na po yung conditions or any condition, then hindi ko pa rin ho yun susundan.
Madam Secretary, if we deal with absolute terms now, there is no condition, it is unequivocal that the Supreme Court is directing you to restrain your department from enforcing the watch list order, would your answer be the same?
I would be in a real dilemma. But it's something that I cannot give a categorical answer now. Although it was my position at the time also that we did intend to file a motion for reconsideration of that order. So sa tingin ko po, at that time, yung perspective ko po, nung time na yon ay hindi ho kami masyadong napakinggan bago nag-issue ng TRO. But again, let me just say that I do not want to dwell further on that because the first two reasons that I have already explained or elaborated on are enough to justify my actions. Thank you.
Sorry, just a few more, Secretary de Lima. Dalawang tanong na lang po, Madam Secretary. Kung sakali po nakasamang palad na kayo po ay ma-disqualify sa kahit anong kadahilanan sa pagiging kandidato at nominado sa pinakamataas na katungkulang Chief Justice, ano po ang magiging reaksyon ninyo dito at ano po ang gagawin ninyo bilang kalihim ng kagawaran ng katarungan?
Definitely, I will not be happy about it, but I will find out and determine whether there is an available remedy for me. I know that the JBC is sort of, well, we can say the sole judge. The question of qualifications or lack of it. But perhaps there would be an available remedy for me. And that is why in my letter to the JBC, I fervently plead for the exercise of this council, the Honorable Council, of its discretion, judicious discretion. And it's even more than the discretion because of that position that I'm advocating, that at this point, those complaints, as referred to the IBP, have not ripened into regular administrative cases. Although on the practical side, just to be on the safe side, I have asked the IBP to expeditiously resolve those cases, hopefully in time for the supposed deadline that was reported in the media as proposed by the Honorable Congressman Tupas. Is it July 30 deadline? And that is less than 1 week. Just for the safe side, but I maintain the view that those complaints at this point should not be considered as legal grounds for disqualification. Salamat po.
Mr. Chair, I forgo with the last question that I have in mind. I think it's been previously asked. I give the floor to the Chair. Maraming salamat po, Secretary Leila.
Salamat din po.
I will just ask a few questions, Madam Secretary. Now, it's your position that disbarment case that was filed against you, it's now pending in the IBP, has not yet ripened into an administrative matter?
Yes po, that's my position.
And that you also filed a motion for, what motion did you file? To determine if there is merit?
For preliminary determination of merit and summary dismissal.
You're borrowing what they usually do in the courts, judicial determination of probable cause. It's likened to that.
By analogy, I actually invoked that argument that just like the rules of the Ombudsman, just like the rules on preliminary investigation, because there's a rationale for that. Otherwise, every potential candidate will be held hostage to any and all types.
But may I remind you, disbarment cases are either filed before the IBP or before the Supreme Court.
Yes, Your Honor.
I think we agree on that. If it is filed before the IBP, then the Board of Governors shall refer the same to the investigator.
Yes, Your Honor.
And the investigator will determine if there is a merit to the petition.
Yes. That's the preliminary determination of merit.
And require already filing of an answer. If he determines that there is a case against the lawyer, then he will require the respondent to file the answer.
Yes, sir.
But if a case is filed before the Supreme Court, it is filed before the Supreme Court, no? And therefore the Supreme Court determines if there is a prima facie case against the respondent, then that rule is not followed. Because that rule is only followed if the disbarment proceedings is filed with the IBP. But in the case of the Supreme Court, and this has been the practice, no? If a petition for disbarment is filed against a lawyer before the court, then the ponente will study if there is a basis to require the filing of the comments.
Yes.
He may recommend the dismissal on the ground that probably the complaint is not verified, or the complaint comes from an anonymous person. Or number two, if it is if the petition is in accordance with the form and substance, then the ponente will recommend the filing of a comment. And after the filing of the comment, then the ponente will determine if there is a prima facie evidence to proceed with investigation before the IBP, or recommend to the Supreme Court for the dismissal of the case on the ground that there is no prima facie evidence. Now, the procedure that was undertaken against you, Madam Secretary, is that petition for disbarment was filed before the court, and the ponente recommended that the respondent should file the comments, and I think that's what you did.
Yes,
Now,
several months ago.
Now, the ponente recommended to the court en banc, and the en banc was unanimous, no, in referring the case to the IBP for further investigation. Now you file a motion for a predetermination if there is merit to it. Do you think that the investigator will go against the resolution of the court referring the case for further investigation, and considering further that the institution of the petition for disbarment was filed before the court? I ask you this because indeed we have agreed that we will determine the qualification of the nominees by the 30th of July. If you file a petition, if you are fortunate enough that they will entertain your petition for the determination, if there is merit to your petition, the petition will not end. If the investigator finds that there is no merit, the proceedings will not end in the hands of the investigator. It will still go to the Board of Governors, the IBP. And the Board of Governors of the IBP will determine if indeed there is no merit. If there is merit, then they can reverse. They can reverse the position of the investigator. So, with time constraint, today is Tuesday, and then by Monday, do you think that there is sufficient time to resolve your problem about this disqualification? I have to ask you this for the benefit of the public and also of the members of the council.
I do realize, Your Honor, that time is not on my side, and that's why I take that position, the first one. Well, it's a layered argumentation on my part. First, that I take the position that does not ripen into regular administrative cases. I was listening to His Honor explain the difference between the Supreme Court proceedings, a complaint filed direct with the Supreme Court and filed with the IBP. Now, there is nothing in the resolution, Your Honors, in the resolutions of the Supreme Court in those cases, because two have been consolidated, the Rivera and the Pedrito case, and then the Sunjam. Now, in both resolutions, there's nothing there about a determination of some kind of a probable cause or a prima facie or a preliminary determination. There's nothing there about referring the cases to the IBP for further investigation. The wordings in those resolutions, if I remember correctly, Your Honors, referred to the IBP for investigation, report, and recommendation. Now, if these are referred to the IBP for investigation, report, and recommendation, then I don't see why we have to consider the mere referral from the Supreme Court to the IBP as already a finding of a preliminary merit or a preliminary